Thank you. Welcome back, everyone. We are coming back to our important topic, and I thank everyone for your continued attention. I just want to offer a quick reminder that we have licensed mental health professionals available. If you need assistance, please let a staff member know. If you would like to speak with them, and our staff will direct you to the appropriate place. They are located in the back of the briefing room, and they're wearing name tags. So if you'd like to approach them directly for assistance. We'll now proceed with the third panel.
Hello? Yeah. Am I on the wrong call?
I think you are. We're going to go ahead with our third panel, which is academics and community stakeholders. Professor
Hello,
Fitzgerald?
Yes.
Yes, you're not on the wrong call. Thank you.
Okay.
This is Catherine Lehman. I'm just introducing your panel, and we'll invite you to speak when it is your turn. But I'm just going to proceed with the introduction.
I'm on the line, Madam Chair.
Thank you, and the Vice Chair is on the line as well. Terrific. So we will now proceed with our third panel, and in the order in which they will speak, our panelists are Christine Back, Legislative Attorney, Congressional Research Service; Tamara Chrysler, Managing Policy Director, Leadership Conference on Civil and Human Rights; Donald Tomaskovich Davey, Professor of Sociology and Executive Director, Center for Employment Equity, University of Massachusetts, Amherst. I went to Amherst College, so welcome. Rhonda Davis, Head of Diversity and Inclusion, National Science Foundation, and on the phone, Louise Fitzgerald, Professor Emerita, Psychology, Women's Studies, and Management, University of Illinois at Urbana-Champaign. Ms. Beck, please begin. And just as a reminder, you have 7 minutes. Please watch the lights, and when the light turns red, please stop talking. Thanks.
Madam Chair, Commissioners, thank you for the invitation to participate in today's briefing. My name is Christine Back. I'm a legislative attorney in the Congressional Research Service. CRS is a legislative branch agency that provides objective, nonpartisan analysis to members of Congress and their staff. Rather than speak about harassment from a policy perspective or a social science perspective, I'll be speaking from a legal perspective to help situate you in how federal courts are analyzing sexual harassment claims brought under Title VII of the Civil Rights Act of 1964. Title VII is the current federal statutory basis for bringing a claim alleging sexual harassment in the workplace. So we'll focus on Title VII itself and on Supreme Court precedent that sets out the relevant standards to apply to these claims. As a general matter, there are at least 3 considerations for understanding how courts are analyzing these claims. First, the text of the statute itself. Second, the Supreme Court precedent laying out the relevant standards. And third, how lower courts are then interpreting and applying that Supreme Court precedent. There are at least several Supreme Court cases to be aware of in this context, and which I discussed in brief in my written statement. This morning, I'll discuss 2, the court's 1986 decision in Meritorious Savings Bank versus Vinson, and the subsequent decision in 1993, Harris versus Forklift Systems, Inc., because both of those decisions set out what I would describe as the core elements that a plaintiff has to prove to prevail on a Title VII sexual harassment claim. The same standard applies to claims that are brought by federal employees who allege harassment under Title VII when they file a lawsuit in federal court. So turning to the text of the statute itself, Title VII has 2 principal anti-discrimination provisions, but we'll examine the first paragraph in particular. That is the language that was before the court in its 1986 Meritorious decision. You'll see the statute makes it an unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to compensation, terms, conditions, or privileges of employment because of such individual's sex, among other protected traits. So you'll see at the outset there's no express reference to harassment, but you will notice in that first paragraph this phrase that it's unlawful otherwise to discriminate against any individual with respect to terms, conditions, or privileges of employment because of that individual's sex. And it's that language that the court looked to when holding in its meritorious decision that a plaintiff can bring a Title VII claim challenging sexual harassment as unlawful under the statute. So the court said in meritor without question, when a supervisor sexually harasses a subordinate, this is discrimination based on sex. And the court said when it comes to discrimination in the terms, conditions, or privileges, the court interpreted that phrase to prohibit discriminatory working environments. So the court in meritor said a plaintiff can establish a Title VII violation by proving that sexual harassment has created a hostile or abusive working environment. That's the standard that applies today. The court in meritor went on to say, however, that not all workplace conduct is going to violate the statute. So what's the standard? The court said that a plaintiff must show that the alleged harassment was sufficiently severe or pervasive to create an abusive working environment to violate the statute. The court, in its subsequent 93 decision, Harris versus Forklift Systems, Inc., introduced another component to the severe or pervasive standard. Under Harris, a plaintiff not only has to show that he or she personally or subjectively found the harassment to be sufficiently severe or pervasive, but also the plaintiff must prove that a reasonable person would objectively view that harassment as sufficiently severe or pervasive. So under meritor and Harris, we have a legal standard that includes terms like abusive, hostile, severe, or pervasive. So one might ask at this point, is this a clear standard? And in a concurring opinion in Harris, Justice Scalia did not think that these terms amounted to a very clear standard for judges or for juries. To give you a brief example of how federal courts then apply that severe pervasive standard, let's take a quick look at two appellate court decisions that appear to address similar evidence. They applied that same Supreme Court standard we just talked about, but arrive at contrary conclusions about whether or not the harassment was sufficiently severe or pervasive. These cases address motions for summary judgment, so the question there is whether the evidence would allow a reasonable jury to conclude that this harassment was objectively hostile. So before turning to these cases, they do involve conduct that is very serious and could be described as egregious, so a brief forewarning about the allegations themselves. So in one case, a Seventh Circuit case from 2010 called Turner versus the Saloon, this involved a male plaintiff, a waiter at a Chicago steakhouse, who alleged that his female supervisor was engaging in sexual harassment. She alleged, among other conduct, that she had grabbed his genitals, had asked him to kiss her, grabbed his buttocks, among other conduct, and the Seventh Circuit said, yes, this would allow a reasonable jury to conclude that this is a hostile working environment. The Eighth Circuit, in a 2005 case called Legrand, also concerning a male plaintiff alleging harassment by his supervisor, alleged similar conduct, that this harasser grabbed his buttocks, reached for his genitals, gripped his thigh, forcibly kissed him in the mouth, sought his participation in watching pornographic movies, among other conduct. And the court in that case said, viewing this claim in light of the, quote, demanding standards set by the Supreme Court, unquote, the harassment was not sufficiently severe or pervasive to violate the statute. So in closing, I'll just note that in addition to the evidence in a case, how courts characterize the evidence will shape its ultimate conclusion. So in the Seventh Circuit case, for example, the one we just talked about with the Chicago waiter, the Seventh Circuit said this harassment was explicit, it was aggressively physical. The court also noted that its own precedent says when there's unwelcome touching of an intimate body part, that weighs heavily in favor of sufficient severity or pervasiveness. So the court said, yes, this meets the standard. The Eighth Circuit in the Legrand case characterized that harassment as isolated incidents, not physically violent or overtly threatening, and the court, including based on that characterization, concluded that the harassment was not so severe. So there's much more to be discussed when it comes to this area of the law. Hopefully that will provide a useful starting point to situate you, and happy to answer any further questions. Thank you.
Thanks, Ms. Mack. Ms. Chrysler.
Thank you, Madam Chair, distinguished commissioners. My name is Tamara Chrysler, and I'm the Managing Director of Policy at the Leadership Conference on Civil and Human Rights, a coalition charged by its diverse membership of more than 200 national organizations to promote and protect civil and human rights of all persons in the United States. Thank you for holding this hearing on sexual harassment in the workplace, and thank you for allowing my testimony. As written in my biography, I've had the honor of working in the field of employment discrimination for over 2 decades. And as many of my esteemed colleagues who appear before you today, I have a comprehensive view into federal processes and procedures. My written testimony provides details of the federal EEO complaints process, as well as some insights into the impacts of that process on the parties and the cultures of the agency. For my testimony today, I would like to focus on the recommendations I make with respect to changing the culture of an agency, as I believe it to be the biggest barrier to addressing harassment in the workplace. Changing the culture of an agency takes time, but it can be done through consistent messaging and consistent action that corresponds with that message. The first message must be that each agency component has its own anti-harassment policy that is periodically reviewed and updated and consistently distributed to all new hires. It is not enough that the component rely on the parent agency's policy on anti-harassment. Having its own policies directly condemning harassment sends the message that the head of the agency recognizes the severity of these claims, their impact on the workplace, and the need to prevent the conduct that leads to such claims. The agencies must live the policy, model the appropriate behavior they want to see, thoroughly address each claim of harassment, and not turn a blind eye to inappropriate behavior or make excuses for it. Implement practices that reduce or prevent inappropriate behavior that become part of the daily operations, like inappropriate jokes and comments. Second, to change the culture of an agency, there must be trust. Trust that managers and coworkers who engage in inappropriate behavior will be held accountable, and trust that the systems in place, like the EEO process, are sound enough to address and resolve complaints of harassment. Agencies can build trust in their programs by complying with procedures, meeting deadlines, ensuring that EEO counselors properly identify the issues so that when the agency accepts the complaint and frames the issues, the accepted issues are reflective of the complainant's concerns. HR staff in particular must develop systems to properly handle requests from investigators for witnesses and documents, which will result in more timely and efficient investigations. Agencies should be mindful of appearances of impropriety and remove from the complaints process management officials who are alleged to have engaged in wrongful behavior. If a conflict exists or the appearance of a conflict exists, agencies must act to correct it. Requiring workplace climate surveys to be conducted after the claims of harassment are presented is another way that trust can be built in the workplace. Harassment claims are not easy on the employees who bring them, those who are alleged as harassers, or staff who are involved in the claim. Trust is often diminished during this process. Employees feel deflated, and there exists a question of how to move forward. There was testimony this morning about aggrieved individuals and alleged harassers continuing to work together in the workplace. A workplace climate survey might be the tool to start that healing. Incorporating administrative inquiries into agency procedures can also help to change the culture of an agency. These inquiries do not replace the EEO process, but would quickly allow an official investigation into a violation of policy, not a violation of the law, and may result in interim relief for an aggrieved individual. Mandating that former federal employees participate in the EEO process, even after separation from federal service, would improve the integrity of the process. It may be easy to enforce such a mandate by simply having the federal employee acknowledge in writing at the time of hire that participation in administrative investigations extends beyond their employment in the federal service. Training for staff who are part of the EEO process is important to ensuring a fair and efficient system, which also speaks to the culture of the agency. Staff who serve as the first points of contact for employees who believe that they are being harassed must be trained to properly address concerns of harassment and not meet employees with indifference or disbelief. When employees bring such claims, these staff cannot ignore the harassing behavior or tell the employee to ignore the behavior or tell the employee to confront the harasser or consider the behavior as just a character flaw of the harasser. These responses are not acceptable. Training managers on how to identify and correct harassing behaviors is key to reducing and perhaps eliminating harassment from the workplace. Managers are in the position to stop harassing behaviors even before they start, or rid work environments of these behaviors before they start to poison the workplace. Modeling appropriate behavior themselves and noting whether staff are modeling such behavior is a proactive approach to ensuring a harassment-free workplace. When managers are found to have engaged in harassing or discriminating behavior, agencies must hold them accountable and ensure that the behavior is corrected. By correcting behavior, I am not suggesting that every incident requires discipline. I do suggest, however, that every incident requires corrective action, whether that action is training for an individual or an evaluation of certain processes to determine where the system failure occurred or where the wrongful behavior was allowed. The culture of an agency plays a vital role in whether an employee will report claims of harassment. Providing a fair process to resolve claims of harassment and allowing sound mechanisms by which employees will be heard tells employees that management does take these claims seriously. However, the same is not true if the agency's process is fraught with delays or there's no integrity in the process. Likewise, maintaining long-standing practices of toughening out unprofessional behavior or considering disloyal anyone who challenges that practice is toxic to a work environment, and it must stop. I want to thank you for holding this briefing today. These are serious issues, worthy of your consideration. I appreciate the opportunity to provide testimony, and I'm happy to answer any questions you may have.
Thank you very much, Ms. Chrysler. Professor Tomaskovich-Davey.
Thank you very much for the opportunity to be here today. At the Center for Employment Equity, we are doing research with data from the EEOC, and I'm going to talk today a little bit about charges filed with the EEOC and their outcomes, which might be of interest. And we also are particularly interested in how employers, as well as the EEOC, deal with those charges. Our estimate is that in any single year, about 5 million employees experience sexual harassment at work, and probably about a quarter of them, maybe somewhat more, actually report it to their employers. And additionally, we estimate that it's more than 99% of the people who experience sexual harassment never file a charge with the EEOC. What's also the case, and you've just heard it, is that men are also in this population. 18% of the people who experience sexual harassment, self-reported, are men, and 19% of those who file with the EEOC are as well. Women are the primary targets, of course, but Black women are at the highest risk. And that's not actually surprising, because sexual harassment is largely, at least in the literature, the social scientists see it as an exercise of power. And Black women are particularly vulnerable as a group. We're also particularly interested in how managers have responded, and we can look at the sexual harassment charges to the EEOC and learn about that. The EEOC's harassment report was mentioned earlier today, and in that they want you to think about sexual harassment as part of a kind of a more general kind of culture of workplaces. Right now, the research suggests that about 20% of workers say in their job they've experienced some harassment in the last year, while in that job. And it's not just sexual, but verbal abuse, bullying, things of that nature. And I think the EEOC was really ahead of the Me Too movement in this by saying it's not just sexual harassment, it's harassment, which gives people permission to then harass sexually. So what are the things that we've learned? Actually, if you just go back for the one, this is the sexual harassment one. In terms of employer responses, more than 60% of people who filed a charge have lost their job, and a higher proportion have experienced retaliation. If you go to the next one, we've also compared this to other other bases for discrimination charges, and it's pretty much across the board. If you file a discrimination charge, you have or will lose your job of at least more than 60%. Sexual harassment actually stands out as having a much higher level of harassment or retaliation behavior after the charge is filed. So job loss is common for sexual harassment, retaliation, and job loss are the common responses to filing a charge. So far, if you get my drift, filing a charge is dangerous. Now, past research suggests sexual harassment is more common in workplaces with a hyper-masculine culture and when management tolerates abusive behavior more generally, which is Tamara's point earlier. We suspect at the center that it's this kind of context where managers are most likely to fail in treating sexual harassment cases seriously and processing them. When we go to the EEOC and try to see how seriously the EEOC has treated sexual harassment cases, if you go to the next one, please. What we actually find is they treat them as or more seriously than other sex-based charges, so that the EEOC is reacting to these charges as seriously as others. On the other hand, the EEOC's basic capacity to act is pretty hamstrung in a number of ways. It's the basic staffing and kind of inflation-adjusted budget right now is about what it was in 1980, even though there are more bases of discrimination claims that they're responsible for, and the labor force has grown by more than 50%. Okay, so what we do find is they treat them quite seriously. At the same time, most individuals benefit little from the EEOC's case processing. Only 27% of employees who file a sexual harassment charge with the EEOC and continue to pursue get any benefit. And among those who get monetary benefits, that's 23%. The median is $10,000. So I want you to think about that. Retaliation, lose your job, 10 grand to go away, basically. Most problematically, only 12% of charges lead to a management agreement to change behavior or practices. Right? When people go to the private bar, 90% of those people who go to the private bar, as opposed to go through the EEOC's process, are turned away. That the lawyers say your case is not good enough. For those for those cases that are accepted by the private bar, 60% receive benefits, and the payouts a little bit higher. However, less likely to negotiate workplace changes, and non-disclosure agreements, which I think are really problematic, are widespread. So what's to be done? Our first point is think about this as part of a more general problem of harassment, and that low-level harassing behavior, bullying, and the like set the tones for acceptable behavior. Much harassment, including much sexual harassment, won't rise to the legal level. And there is stuff in the literature that tells us what does work, and hopefully we'll be able to talk about that a little bit more. The EEOC's recommendations, they talk about leadership and accountability, structures in workplaces. We heard about that earlier this morning. I think in the scientific literature on this, transparency is really important. You can't just say we have a policy. You have to show your workers and the outside regulatory agencies, I would say, what you're doing and why it works. And you have to think about why it doesn't work when it doesn't. And the last thing is we have to have metrics. You can't have accountability. You cannot have transparency if you are not keeping good records. And those records include the outcomes of the cases. Thank you very much.
Thank you very much. Ms. Davis.
Good afternoon. Thank you, Madam Chair and Honorable Commissioners. I'm very pleased and honored to be here today. Dr. France Cordova, who is the director of the National Science Foundation, sends her regrets that she's not able to attend. She's very committed to this topic. She's taken a very assertive posture to eradicate sexual harassment in the scientific research community that we find. And back in February of last year, I had to testify before Congress. And it was a part of their review of sexual harassment and misconduct in science. We were the federal agency that had to testify, and I believe that's for multiple reasons. We found approximately 27% of basic research in the U.S., which is about $8 billion. Several prominent principal investigators funded by NSF were in the news for sexual harassment. And the fact that a couple years prior to then, we had taken an assertive posture to try to address sexual harassment, the director sent out issued an important notice to the entire grantee community that NSF will not tolerate sexual harassment within the agency, at the awardee organizations, field sites, or anywhere science is done that NSF funds. In conjunction with this notification to the approximately 3,000 colleges and universities that we fund, there was a concerted effort to bolster our Title IX program. We hired a senior Title IX program manager to begin doing Title IX compliance reviews and helping us bolster the things that we were failing to do in our role as a federal agency. We think this interest piqued, that this highlighted effort piqued the interest of Congress, and they requested us to come. It also piqued media and others too. We often get asked, why did we take the steps and why was it important? And there are multiple reasons. It is the law to not sexually harass. People who create unsafe environments, they disrupt the entire scientific ecosystem, discourage scientists, particularly young scientists, from contributing and harming their careers and scientific progress. It's our mission to protect and promote fundamental research and to broaden and increase participation in STEM. As the primary funding agency of fundamental science and research in the U.S., NSF recognized to enable scientists, engineers, and students to work at the outermost frontiers of knowledge, the agency must be a role model for teamwork, fairness, and equity. That is why we announced the steps last year to help eliminate sexual harassment from science and engineering through a new award term and condition that makes it very clear to the awardee organizations that if NSF has a funded investigator or co-PI who has committed sexual harassment, we want to be notified. If there's administrative action, we want to be notified. Due to the importance of this issue, we took it as a priority and fast-tracked it. The new award term condition went into effect October 22nd of last year after the Federal Register notice. When we put it in the Federal Register, we got over 200 comments. That's more comments than we ever received on our Federal Register notices. They were all fully supportive of what we were doing. Then they split 50-50. 50% say we didn't do enough, 50% say we went way too far overboard. We think we landed somewhere in the middle. We didn't make anyone happy. But we plan to conduct evaluations in the future to determine if the term and condition needs any modifications. We don't want this good thing to be harming, and we don't know exactly how effective it is. So that's in our future plans. The new term is entitled Notification Requirements Regarding Sexual Harassment, Other Forms of Harassment, or Sexual Assault. The reason we added those in there is because we learned, just like you said, it's not just sexual harassment. Other forms of harassment play a role too and impacts gender discrimination. So we think this is going to be one solution that will be fairly effective, and hopefully after we evaluate, we will be able to prove that. But these are the things we consider at a minimum when we are looking at, when we're notified that someone has sexually harassed a student, postdoc, or someone in the academic community we fund. The safety and security of the personnel supported by our award. The overall impact to the NSF-funded activity. The continued advancement of taxpayer-funded investments in science and scientists. And whether the awardee has taken appropriate action to ensure continuity of science and that the continued progress under the funded projects can be made. Ensuring the safety and security of the people our award support has and will continue to be NSF's top priority. At the foundation, sexual harassment is not a trending topic. For many years now, we have funded research and proactively facilitated interagency working groups so that we can gain a better perspective and propose effective solutions. NSF also expects all awardee organizations to establish and maintain clear standards of behavior to ensure harassment-free workplaces. To mine the best ideas, the director instituted a cross-agency special task force to examine and collect promising practices and model codes of conduct, which are now being published on one web portal at nsf.gov/harassment to make it clear. and make it easy for the research community and the public to access this information. These new steps and resources complements NSF's Title IX compliance program, which we have already bolstered. It's meant to ensure that the actions of one do not negatively affect the careers of all. It is vitally important that the work that we do not impact students and postdocs. We'll do everything in our power to prevent that. I also would like to mention that we were a major funding of the National Academy of Sciences and Engineering and Medicine's Sexual Harassment Report. This is one of the most comprehensive examinations to date of sexual harassment in academic science and engineering and medicine, as is based on rigorous research in this area. It also supports some of the same things we've heard about women of color and certain categories that sexual harassment impact even more than what you would just think on the surface. So I know I'm out of time, but I would love to participate in any Q&As. Thank you.
Thank you, Ms. Davis.
Thank you.
Professor Fitzgerald.
Good afternoon, everybody, and thank you very much for inviting me to speak. I do wish I could be there in person, and I hope you can hear me.
We can, thank you.
Everything I'm going to say, I think it has already been said, but hopefully I'll say it a little bit differently. As an academic, I have been studying this topic since most of you were probably in middle school. And I'm going to talk today about the common elements of harassment, the things we know for certain about this topic and how it operates across organizational settings, from NASA to General Motors. And the first thing I want to emphasize is that harassment is rarely about sex as a verb. And what I mean by this is this. We are used to thinking about harassment as sleep with me or else, or repeated, unwanted, annoying sexual attention. And that happens, of course, and it's what usually hits the newspapers, and it's one of the reasons we're all here today. But that is very much the tip of the iceberg. The great majority of harassment in any organization falls into a third category, gender harassment, which is better thought of as sexist or sexual hostility. It has nothing to do with sexual desire. It is not a come on. Rather, it is a put down that conveys contempt for women as workers and sends a not so subtle message that they are outsiders who do not belong. It includes the pervasive comments denigrating women as stupid or incompetent, treating them as sex objects, or referring to them by degraded names for their body parts. It includes pornography and unwanted text messages, including of erect penises sent by people you don't even know. As long as we think of harassment as efforts to get a date, plus a few random sociopaths, we are missing 90% of the problem. The second thing we know is what we don't know, and that is how widespread this problem actually is. No one knows the true answer because the necessary national studies have yet to be done. But from many years of research, we know enough to suggest with confidence that 1 of every 2 women encountered some form of harassing behavior during her working life. And has already been mentioned, one thing we do know for certain is that the problem is more widespread in male-dominated workplaces in which the majority of employees are men, whose job duties and tasks are those that are traditionally performed by men, such as police work, firefighting, science, and where the supervisory and managerial roles are more likely to be filled by men. Researchers refer to this as a masculine job-gender context, and every study ever conducted confirms that such workplaces have far greater problems. We also know that harassment is not a matter of individual deviance and that there's no such thing as a typical harasser. It is true that some individuals are more likely to harass than others, but it is also true that organizational conditions, and this has been said very clearly and articulately by earlier speakers, organizational conditions can inhibit harassment even by those who are otherwise likely to do so. Along with job gender context, organizational climate and culture is the most powerful factor in determining whether harassment will occur. A climate that tolerates harassment is one in which employees believe this topic is not taken seriously, that it is risky for them to complain about it, and that nothing meaningful will be done. These workplaces have far greater problems with harassment, and victims suffer far greater damage over and above the impact of harassment itself. Conversely, research shows that workplaces whose employees understand that it does not tolerate such behavior can inhibit harassment even by those with a propensity to do so. We also know that encouraging more reporting will not create such a climate. Although safe reporting channels are obviously necessary, reporting alone will never solve the problem, if only because it comes into play after the harassment has occurred, and at best may eliminate or improve the behavior of a single or a few individuals. So what to do? By this point, you will not be surprised to hear me say that the most important actions any organization can take are: 1, to increase gender integration, both horizontally and vertically, and 2, to create an organizational climate that will not tolerate sexual harassment. With respect to gender integration, this is difficult. Affirmative action programs are politically incorrect these days and increasingly legally challenging. But it is demonstrably the case that organizations that are characterized by such integration, both vertical and horizontal, have far fewer problems with sexual harassment. So we need to figure out a way to do it. At the same time, we must work to create a climate that does not tolerate this behavior. Someone spoke earlier about transparency. Climate is all about employee perceptions, which are critical because they drive employee behavior, both offenders and victims. Actions that can influence employee perceptions include visible interventions such as a strong and visible leadership stance, raising the issue proactively and repeatedly, instituting clear policies and procedures, and following through with meaningful sanctions, assessing progress with annual workplace audits, and providing group-level feedback to employees. Now, these are obviously not quick fixes. Like turning a battleship, organizational change takes a long time. But the methods are available, they work, and they are not particularly complicated to implement. We just have to do it.
Thank you, Professor
Thank you very
Fitzgerald. I'm going to open now for questions from my fellow panelists. Professor Degler?
Not yet a professor.
Commissioner.
One can aspire, and perhaps I've been encouraged by the wonderful testimony of our witnesses today. I wanted to ask Professor Degler, I want to get it right, so if you could say it for me, I'd appreciate it. Professor Thomas Kovic-Deep, could you help us understand? You said that we can know what things help and things we
I'm
should.
sorry, are we still here?
We are still here.
Okay.
I was asking, to the extent you said that we know what works, is there data that supports the interventions that work? Are there studies and data that show us these things?
There's studies.
Your microphone is not on.
Sorry.
Thank you.
There are both studies that show things that don't work, but might be worth asking about as well. On the work side, what we see is when there's accountability structures, that means that the managers themselves at all levels, not just the leadership, are evaluated partly in terms of outcomes, that works. It changes behavior. Right? Accountability can also happen in small groups, like in hiring committees. We have a much more diverse hiring committee. It's not about sexual harassment, but it's part of a thing. So accountability is important. The idea of transparency, which I think you're hearing back and forth here, which is that in order to change behavior, people have to see what's happening, right? So then the kind of the common legal approach to sexual harassment and other forms of discrimination, the information that gets collected tends to be suppressed, made confidential, and the like. Often perpetrators and victims are paid to go away, right? What that means in the next round, nobody in that workplace knows when management has even taken an action, right? Which means people can, any sense of distrust in the system can go on, right? One can think about organizations that are increasingly transparent. So like Airbnb is really a good workplace for women. And they publish their diversity numbers on the web, right? They've got twice as many women in tech and managerial jobs as the rest of the tech workforces. And they're putting it out there. Now it's probably more important actually for the laggards to do the same, right? So the last thing that works and was very much a part of the panel, the NASA conversation earlier today, is you can't do accountability or transparency if you don't have metrics. You have to collect the data, right? That's one of the reasons why I sort of hit you with data like, oh, retaliations happen at 78% of the time. Unless you can answer that question from a management point of view, right? You also just don't know where your problems are. And
Following up, how does one navigate the tension between confidentiality on the one hand, because there is a role in some situations for confidentiality on these matters, with the transparency imperative that you've spoken to? I take it that not all of confidentiality is supported by bad motive, that there's some bona fide reasons that drive it, and how do you navigate that? What's the just right solution?
I'm not sure, but all the data I showed you today is confidential data. But I didn't show you any of the confidential bits. Right? And so, for example, a company or a federal agency, if it's keeping its own records, right, it can then publish the aggregate record. Okay, how many kind of problems of managerial kind of counseling on harassment behavior versus discipline on harassment behavior has gone on, and what was the outcome? Right? You don't have to say it was Joe, but you do if you publish that this company is doing something and there are some actions taken, well then that actually both has a message to the harassers and the people being harassed. And these things would apply to other forms of discrimination as well.
So, for example, federal agencies could have a dashboard in these
I'm
different...
not sure I'm hearing all this correctly, but if I am, and you're talking about how to be transparent and at the same time be confidential, the university, I think it was of Minnesota, has been doing this for something like 25 years. They publish anonymous data that describe the number of harassment complaints, the nature of the offenders, the nature of the complainants, the nature of the behavior, the nature of the decision, and the nature of the action that was taken. And they publish it every 6 months.
Could you send us a proposed federal agency dashboard of the categories that federal agencies might put up and make available in this way that navigates this? We'd like your further ideas on what the possibilities are of best practices.
I'd be happy to do it. Maybe I'll collaborate with Louise on that.
Right. Next question.
Sounds good.
Next question to the panel, and I'll throw it up as a jump ball. You can all fight over it. So this concept of reporting being dangerous, I think, is a very, very important concept. We've talked a lot about it today in different ways, but I think we need to understand some of the nuances here, because if there isn't a way to change that paradigm, we were never going to have reliable data. We're not going to, our dashboard information is not going to be representative. Serial violators are going to have cover and continue to perpetrate it. And so how do we navigate and break down aggressively the retaliation that has been described to us today?
I'll start with saying that it starts from the top down, and it is practice and policy being consistent with each other. So as I mentioned earlier, ensuring that each agency component has its own policy, but following the parent component, following the parent department's agency, but having their own policy, as well as ensuring that the practices of the agency, the practices of the managers, the practices of the employees comport with that policy. Professor Thomas Skovic, DV, mentioned that perception of the employees creates the culture, and that is true, and their perception is their reality, right? So we know that perception is reality, and when the body of the employees perceive the managers just putting forth the policy, just having this paper on file, but not living it and not practicing it, that's a problem. So aggressively breaking down retaliation starts with ensuring that the leadership of each agency is ready to step forward and say, we are not going to allow this anymore. And when they see it, stop it. It's not just on paper, it's what they are allowing their managers to do and requiring their managers to do.
Your microphone is not on, Mr. Wilson.
I thought I pushed off. I agree totally with what you just said, Tamara. Also, when I think about the director, and she started this task force, she meets also with us in all of her senior leadership. They must come to these meetings. And then they cascade down. Those senior leaders also meet with their senior leaders. So it's no excuse that anyone in this organization can say that they do not know what they're supposed to do and what may happen if they do it. So I think I agree with you. It's a top down, but it just can't be at the top talking to a few people. They all must cascade down. And so when we are in any meeting, anyone, yes, zero, if it existed, well, they are very much aware of our stance on a no tolerance policy as it relates to sexual harassment. Also, bystanders are very much aware of that their role to come and let us know if they see something in case someone is afraid of retaliation, so we can kind of dive in and deal with those issues for the people who may be experiencing something and afraid.
Well, it is very definitely true that it is extremely risky. We've done some of that research, and what we find is that with respect to victims' welfare, that reporting at best makes no difference and quite frequently does make things worse. Now, that's sort of a black box for us, but like why that happens. But the obvious implication is that it's the reaction of the organization to the complaint, and because victims who report have, Lord, they have more psychological distress, they have worse health outcomes, and they're more likely to leave their jobs.
I wanted to add
Even after you take into account the harassment itself. So I think it is that issue of culture and climate.
So I wanted to add two things. One is that sort of the tenor of my remarks was to be skeptical about the protection that's offered by the legal process. And I'm not just skeptical of the EEOC here. In fact, I think the harassment report that Chair Commissioners Lipnick and Feldblum wrote actually points much more towards this has to become a normal managerial responsibility. By the time it becomes a legal problem, we failed. And at the firm level or the agency level, once you treat something as a legal problem, it's no longer a managerial problem. It's a question of guilt, which means we've already failed at the managerial goal. And so I also, so I wanted to say that as a caution, and then kind of more pragmatically, to the extent that there's kinds of things like employee satisfaction surveys and climate surveys, at least the federal survey in many agencies is not well integrated with the EEO process. They're done by different offices that may or may not be talking to each other. And on the social science side, it's really, we know how to do climate surveys where you could actually target and say, okay, what are the particular niches in your agency where this kind of abusive behavior is problematic? That is, these things are discoverable. And I don't mean discoverable in a legal sense. I mean in the same sense that if you had a production line in a factory and it was turning out shoddy goods, you'd want to know.
Professor, when you refer to the climate survey in the federal agencies, are you referring to the employee viewpoint survey or to something different?
I was referring to the employee feedback survey. Yeah.
Thanks. Commissioner Saki?
Thanks. I am very curious as to why, for the few plaintiffs, the people who complain actually see their cases all the way through, why they are not successful in getting the relief that they want. So is there a problem with the legal standard? What is the problem that, I agree with you that if it gets to the legal system, you have failed on one level, but once you get to the legal system should work. So why is it not working? What needs to be done there? I have stumped all of you.
Well,
Well, I think you said something earlier about, there's the law and then there's the way that the judges interpret the law. And so not everybody is necessarily on board with the fact that grabbing somebody's buttocks is severe. And so obviously judicial education, that's where also expert witnesses come in, although judges don't tend to like them. But it does explain to juries why this is bad. I spend a lot of time in front of juries explaining this is bad and this is why.
Commissioner, the Supreme Court itself has said in its own decisions, it's characterized its standard as making clear that only extreme conduct under that standard is a violation of the statute. So to give you a sense of how courts characterize the applicable standard, and in the Eighth Circuit case that we just discussed today, the Eighth Circuit characterized the Supreme Court standard as demanding. So to give you a sense of the applicable legal standard, courts, the judicially created standard courts often characterize it as a difficult one to meet.
So do we need to, does Congress need to change that standard? And does it need to be clearer about if we use severe and pervasive, what does that mean? I mean, it's shocking to me that under any standard, grabbing someone's private parts is not somehow seen as severe in this day and age. But.
Well, certainly it's an option for Congress to pursue. This standard is a judicially created one vis-a-vis statutory interpretation. So certainly an option that Congress could undertake if it chose to is to clarify or create another standard, perhaps.
Great, thank you. I know I have the name Narasaki, so I'm sympathetic, so I'm going to murder your name, but Professor Tomaskovic, DP. So in your report, you talked about the EEOC data that compares Black women to white women's experiences and left everyone else at other. But the EEOC data does actually include data on Latinas and Asian women who have lower incidences. But is there any studies looking at whether there are lower numbers of charges because they are not reporting, or is it that actually they are? I would be shocked to think that they're not experiencing it. So I'm wondering what research there is.
So there's actually been very, very.
They may be less likely to report. I don't think anybody really knows. It's very hard to know. I mean, with all due respect to the EEOC, who I love dearly and testify for and work for, and but it's very hard to learn what's really going on from their numbers because those are by definition kind of outliers, the people that report. And so I don't know how much we can generalize. My guess is that it is much more difficult for women, and this is a guess, and it's like, for women of color, they have so many more barriers, socially, economically, whatever, and maybe more to lose. But it would not, I would not assume that it's because they have less harassment. In fact, I think the National Academy of Sciences study suggested that they were more likely to be harassed.
Yeah, so I think that Dr. Fitzgerald's position here is right, which is that we don't have much in the way of good national studies, and occasionally we'll have a local study, and the National Academy of Science one is the best. And I did want to do a kind of a shout out to the to acting Chair Lipnick at the EEOC right now. She's really, over the last year, internally at the EEOC, has done some really remarkable work to increase the research capacity of the EEOC, which historically has been very, very weak. It's been a regulatory agency, and so it doesn't actually often ask those kinds of questions. But I think these are the kinds of questions we should be asking.
So you're, sorry, go ahead.
Let me just say
Sorry, Ms. Davis is next. Thank you. I agree. The Nason report is one that we rely heavy on, not just because we fund it, but we think it's really scientifically sound. We put out a couple of Dear Colleague letters as a result of those reports, and we are asking to have some research done around sexual harassment experiences for women of color, the disabled, etc., in various fields, but that they would probably be limited and wouldn't be nationwide for everybody. We're more interested in looking at those women of color in science, but I think this would be a model for others to model the same type of research. Great. I have a third question, but I would like to ask the panel if you can, after the hearing, if you have suggestions about what kind of research we should be recommending, that would be very welcome. So my third question is to Ms. Davis. I'm very intrigued by the work that your agency is doing and trying to get the people that you give money to and to affect the broader field. I'm wondering, though, how you are going to combat the potential problem of if you are a grantee and you're getting money and you're being asked to report these things, and the threat is that you might lose your research, whether that will have the unintended consequence of people whose livelihood depends on that research being funded, feeling like, well, maybe I can't report because that creates a risk that is also a problem. I agree. We spent a lot of hours chatting about that and trying to figure out how to address it. What we did simultaneously when we came up with this new term and condition, we increased the Title IX activity, which is a compliance activity. And we also did an extensive outreach effort to let everyone know that we have a portal that they can go and report directly to us, anything they observe, any experience they had or any experience of others. So we're trying to use these as a cross check. So if we hear a lot of things we hear from the media or school newspaper, and we do a lot of Google searches ourselves, and we're seeking this information. So I think it's at a university's own peril and very risky to take that step because we're not relying just on that university to tell us. But it's a part of our term, it's a term and condition. So if we learn through any form that something happened they did not tell us, that's even riskier for losing the funding. And do you do that kind of research before you give a grant? Pardon me, I'm not clear what you're saying. So if someone is applying for a grant, yes, do you look at, do you Google or do you do searches to see whether in fact there have been issues?
No, because we fund the institution and not the PIs, and we don't want to put anybody on a blackmail list where we are interfering with our merit review process. When they apply for a grant, we want it to truly be based on the merit review process. If we hear that it's someone who has had problems over and over, then we handle that on the Title IX compliance side. We can go out and do a compliance review of any institution. We would not stop the award, but we do a compliance review. And if we got out there and did a compliance review and we found out there were problems and the university wasn't addressing, then they would have to bring it into compliance, whether that is a replacement PI, whether that is some form of addressing the issue of the person, whoever is alleged to have committed some form of harassment, sexual harassment. But we do not let it interfere with the merit review process. We want to keep that pure and separate.
So NASA, in their process, they are actually going out to the people they give contracts to and looking at at least their procedures,
Right.
to look at whether they feel it's up to standard. Do you do that?
We do the same thing. Actually, we've done joint compliance reviews with the NASA staff, with the Department of Energy staff. We have the same authority, and we do the same type of Title IX compliance reviews. That's separate from our term and condition.
So you don't do that as a check when someone's applying for a grant to see whether their procedures are up to snuff before you give them the grant.
So that's called a pre-award compliance review. We have some preliminary pre-award compliance reviews, but it's not very detailed. If we've heard a lot of activity, we could pick up the phone and call the Office of Special Research, Title IX office, and start having a conversation about what we've heard. And I'd like to make it clear about our new term and condition. We are requiring them to notify us. But prior to then, if we heard it through any form, we would pick up the phone and call and have a conversation. The new thing that's happening now, they are required to notify us. But if someone here say today that something's going on, we're going to follow up to find out and have a conversation with the Office of Special Research. And also another thing we learned from that, Title IX offices and Office of Special Research, they don't communicate. The Office of Special Research is the one that signed the grant to say there's no discrimination that's happening here. No sexual harassment. And the Title IX office is the one aware of all that. So as those people are signing federal documents that nothing is happening that they have no clue about. So our term and condition is forcing the two offices to communicate. It's really helping them to not lie on a federal document. And so we're looked at this, how can we approach it from multiple angles? With Title IX is something you have to go back to Congress. There are quite a few bills out there as a result of some of the things we're doing that some of the members are trying to get through. But that would be a huge battle, and we're losing a lot of time. So we want to bolster Title IX, and we brought two other components. That's the term and condition, and then the outreach effort to reach out to us and let us know what's going on, and we will follow up, and we do.
And I know it's a recent term and condition, but has anyone reported?
Absolutely. We're having people who are reporting that are not required to report. What do I mean by not required to report? So the way we do it, in is if we come with a new term and condition, we do not make it retroactive. So October 22nd, this term and condition went into effect. And what it says to all the awardees that receive funds for us, if you have a new award after October 22nd, or you amend an old award after October 22nd, and you take some action against a PI or made aware that a PI has sexual harassment, we want to know about it. So if it's something that an award that happened before October 22nd, they don't have to report that to us. But if we hear it through another form, we still will go to them and address it the same way.
Great, thank you, Madam Chair.
Thank you, Commissioner Degler.
I have a follow-up question on this point. So one way that agencies require folks to tell them what they need to know is at the time that organizations are signing, that entities are signing to receive their federal funding, they have a list of certifications. There's something called the False Claims Act, and making a false statement can subject you to very significant federal penalties, as I understand it. I'm wondering if this new approach has been codified in that way so that there can be a very clear certification that the disclosure has been made at the time that the funding is distributed, if that's the way you're doing it or if it's in a different way.
You're absolutely right. So once they, it's a grants.gov process. When they come and they'll check that they certify that they are not in the Title IX violation, no civil rights violation. They're certifying for the institution that they don't have any violations and that they're in compliance with the civil rights activity, which is done by the Office of Sponsored Research. And that's been going on all along before we came with the new term and condition. But as I was saying earlier, most Office of Sponsored Research have no idea if the Title IX office has a violation going on, or if someone has done something that's involved in sexual harassment. But you're right, that False Claims Act. When I spoke to Koger, and it was all university people, when I said that, you should see the look on their face like, oh my God, we've been citing tons of these and we haven't even talked to the Title IX office. We really don't know. Is it a violation or not? So you're right, the False Claims Act does apply here.
Thank you. So one of the themes from today, as I've heard it, is that agencies have very different ways of approaching this issue. And one of our jobs is to think about whether there is some uniformity or greater emphasis under federal law that could help us get to the standard to which we aspire. I take the point that there is some skepticism about the role of the law in addressing these things as opposed to management. But I'd like to say that one of the things that focuses managers is managing risk. And a risk is liability under the law. And so, for example, corporations across the country have compliance departments. They have compliance departments because there's a complex network of federal and state obligations that could pose risks, reputational and monetary risks for companies. And so people are charged with the managerial and business responsibility of managing these things. So I think it's important not to necessarily disentangle these things. I think we have to have an accurate articulation of where there are opportunities for success, but also understand that there may be a cross-pollination of these two things. And so trying to lift up both sides may be the best approach. With that too long précis, is there a way to envision a set of best practices that is nimble enough for the broad swath of agencies to think about and not have it so idiosyncratic as to every agency that, you know, our 2 million federal employees are having their practices made up one at a time, agency by agency, and employees are being transferred through agencies or moving through agencies and perhaps, continuing practices that were not okay in one agency and another federal agency. Is there a minimum, a set of minimums we could get to?
I think if we ensure that practices follow policy, then we can have that consistency. And I think that if we ensure that every agency is training their staff, their managers, their EEO, and my testimony focused on training HR staff, EEO staff, and managers, but there's employee training that should take place as well. We have coworker harassment that's just as prevalent as manager harassment. So ensuring that there is training, and not just onboard training or when there's a problem training, but annual training, so that the message is continually sent. This is not acceptable. This is what we expect of our workforce. And this is what we this is the model that we are giving. So yes, it's difficult with hundreds of thousands of individuals in different cultures and different climates, but when we look to create those climates from the policy and ensure that the practice stems from the policy, I think it's manageable.
I'm pretty
I
skeptical.
don't want to be a naysayer here, but first I want to say that the research shows that by far most harassment is by coworkers, not managers. The naysaying part is that everything we know about training says that it doesn't reduce harassment. And I think you can take a look at what the National Academy's report said. You can look at what the EEOC 2016 report said. Training is problematic for employees. Very important for managers because they need to know what to do. But I think we haven't maybe we figured out sort of how to do it, but it's with such large scale requirements you simply can't train people this way 50 at a time and have them sit in a room and look at a slideshow and have a discussion by lawyers. It doesn't work, and sometimes it's counterproductive. It needs to be done in small groups. It needs to be interactive, and that is a big financial cost.
And I was going to start my comments by saying I'm also skeptical of training. And I think the research on this is both anti-bias training tends to not work, partly because it's trying to change kind of deep-seated cultural stuff. It's a hard thing to change, especially in a couple of hours. Any of you who've sat through it painfully probably know what I'm saying. Legal training actually is even worse. Legal training tends to produce backlash. It instructs managers, oh, don't hire those people. Now that doesn't mean there's no training that could work. Okay? So I mean, the kinds of training the kinds of things that I was talking about before, accountability, transparency, and the like. I think also formalization, which was talked about this morning a little bit. These are things that decision makers and managers and workers can be trained about. But if you try to just eradicate the bias or threaten them with legal consequences, training is unlikely.
That's a terrible thing to do.
And I actually this morning when you guys were going back and forth with NASA and the State Department about training, you were asking how much training, and I kept thinking, no, ask them what about, what's the content of the training?
Right. You know, some people are suggesting that civility training, and this was in the National Academy's report, it's less contentious, and that, you know, I didn't have time to talk about this, but that incivility is kind of like a gateway drug for harassment of various sorts. And training on civility and workplace respect is much less contentious. And that seems to be one of the roads of the future. And I don't know, we don't know yet how effective it will be, but what we do know is that what happens now is not effective.
I did. I just wanted to respond to some of the things my colleagues said, and so glad that Professor Fitzgerald mentioned the civility training, because that's something that I was going to mention. The type of training, there's certainly some training that can be more productive than other training, and making sure that the training is part of a whole change is essential to ensuring that the training is effective. So looking at it by itself and having training as the sole solution is probably not the most effective way to go about it. But I really do want to emphasize from my experience, my belief that training is so very important, because not only does it, honestly, some folks don't know. Some employees don't know. No, you cannot say that in the workplace. No, you cannot do that to your colleague. No, that is not acceptable behavior in a professional environment. People need to know that. But it also sends the message that management is laying its expectations. This is what we expect in the workplace. We're not going to assume that you know, so we're going to provide this information to you. And now that we know you know, these are the standards that we're going to hold you to. So yes, putting some thought into what type of training for the particular agency is important. But having that training, sending that message, and holding employees and managers accountable is essential to eradicating harassment in the workplace. Thank you for that opportunity.
Thank you, Ms. Davis.
I'm just going to follow back up on what you asked. In the Nason report, they also, recommendation 13 deals with increased federal agency action and collaboration. And they've also done a lot of work up on the Hill. And so it's some bills that are going through that has a lot to do. These are science focused, but I think these are things that could expand out. It's not limited to science as it relates to federal agency action and collaboration.
Thank you. With that, I thank this panel as well, and Professor Fitzgerald, thank you for participating by phone. We will reconvene at 2:40 p.m. and thank you all. So we will now turn to our fourth panel, and I will say just before we begin that Commissioner Harriet will have to leave to catch a flight in the middle of the panel. It is not a comment on anything anybody says when she when she walks out of the room. This panel is the Legal and Community Experts panel, and in the order in which they will speak, our panelists are Darely Rodriguez, Director of Economic Justice Project, Lawyers Committee for Civil Rights Under Law, Mona Charan, Senior Fellow, Ethics and Public Policy Center, Jane Liu, Legal Director, National Asia Pacific American Women's Forum, and Deborah Katz, Attorney, Katz, Marshall, and Banks. Ms. Rodriguez, please begin.
Madam Chair and distinguished commissioners, thank you for the opportunity to discuss harassment in federal workplaces. My name is Darely Rodriguez, and I am the director of the Economic Justice Project at the Lawyers Committee for Civil Rights Under Law. The Lawyers Committee is a national civil rights organization created at the request of President John F. Kennedy in 1963. For the past 5 decades, the Lawyers Committee has been on the front lines of the fight for equality in the areas of economic justice and more. Almost 55 years after the passage of the Civil Rights Act of 1964, workplace inequality persists. American workplaces continue to deal with the lasting effects of discrimination stemming from America's history of slavery, Jim Crow, and racial segregation. As one of the first sectors of the economy to desegregate in the 1960s, federal government jobs historically have been a path to the middle class for communities of color. Yet the federal government workplace is still struggling with occupational segregation and power imbalances. The federal workforce remains majority white at 63% and majority male at 57%. According to recent figures from the Office of Personnel Management, nearly 80% of senior executive positions in the federal government were occupied by white workers in 2016, while Black and Latino employees comprised a mere 11 and 4.6%. Respectively, of senior executive positions. Among the 43% of women who are federal employees, only 10.8% of them are Black and 3.5% are Latino. Unfortunately, sexual harassment continues to be an issue for federal employees, according to the 2018 U.S. Merit Systems Protection Board report, with approximately 1 in 7 federal employees, or 14% of the entire federal workforce, experiencing harassment in the past 2 years. So we must squarely focus our conversation regarding harassment in federal workplaces against this backdrop and recognize the ways in which socioeconomic status, race, ethnicity, LGBTQ status, disabilities, and other factors shape the experiences of federal female employees of color. The Me Too movement, founded by Tarana Burke, an African-American civil rights activist, has exposed the prevalence of sexual harassment in all segments of our society. The national conversation that has resulted from Me Too going viral has encouraged many survivors of sexual harassment and assault to come forward and to share their stories. Unfortunately, too often the experiences of women of color have been ignored. Therefore, we urge the Commission to incorporate in their recommendations the principle of intersectionality, that people living at the intersection of multiple forms of oppression face cumulative and distinct harms. Women of color are more likely to experience sexual harassment and assault. Between 2005 and 2015, women filed 80% of all sexual harassment charges, with Black women being the most likely to file a claim of sexual harassment. 1 in 17 sexual harassment charges filed with the EEOC also alleged racial discrimination. Women of color are more likely to experience harassment in compounded ways on the basis of their gender and race or ethnicity. For example, an article by The Guardian reported that Ms. Elisa Lopez Crowder, a Navy veteran who started working for the U.S. Forest Service in 2010, was subjected to racial, sexual, and physical harassment by one of her supervisors. According to Ms. Lopez Crowder, he told her that he didn't believe women belonged in fire, made derogatory remarks about her skin color, and physically assaulted her. Most victims of harassment, however, will not come forward and file complaints for fear of retaliation or inaction on their claim. In fact, 68% of sexual harassment charges include an allegation of retaliation, with Black women being the most likely to experience retaliation. Women of color with limited economic resources who rely on their jobs to support their families may feel even more deterred from filing a complaint for fear of losing their jobs. Workplace harassment has significant and harmful consequences for survivors. Negative effects on mental and physical health, reduced career development, and forced job change or unemployment are just a few of the disruptive and sometimes life-altering effects of workplace harassment. A growing body of research shows that for women of color in particular, experiencing racism has direct biological effects that causes increased rates of disease and disability. African American women who experience racism are more likely to have hypertension, and African American mothers who deliver preterm infants of very low birth weight are more likely to report experiencing racism during their lifetime. For many women of color, race and sex harassment often occur at the same time and result from power differentials and occupational segregation. While only a small percentage of survivors come forward to file complaints of harassment, unnecessary barriers that make it more difficult to file a complaint must be promptly fixed. Federal agencies must take meaningful steps to audit the effectiveness of their internal harassment procedures and ensure that their policies, procedures, training programs, and internal complaint systems are effective and responsive to all complaints and to the ways in which women of color and other marginalized employees experience harassment. In addition to fixing broken internal harassment policies and procedures, federal workplace cultures must change. Leadership within federal agencies must reflect the communities they serve and must prioritize tackling all forms of employment discrimination, including in hiring and promotion. We must do everything that we can to eradicate harassment root and branch from our federal government workplaces. We thank the Commission for undertaking the work to ensure that our federal government is at the forefront of protecting the rights of all American workers. The Lawyers Committee, in our fight for racial and economic justice, will continue to do its part. Thank you.
Thank you very much, Ms. Judd.
Thank you, Madam Chairman, members of the Commission. Glad to be here. As mentioned, my name is Mona Charan. I'm a syndicated columnist, an author, and a senior fellow at the Ethics and Public Policy Center. My most recent book examines the role of feminism and the sexual revolution in shaping some of the social problems that we are experiencing as a nation. I argue that the sexual revolution has not served women well, or men for that matter, and the Me Too movement is a long overdue backlash against it. On the whole, with some exceptions, the Me Too movement has been a necessary corrective to years of gross behavior by powerful men. Most of the prominent men in politics, media, sports, and entertainment who've been identified as sexual predators have not even attempted to deny the accusations. But I think it would be a mistake to see the issue of Me Too as a civil rights matter. As Samuel Johnson wrote in the 18th century, "How small of all the human hearts endure that part which laws or kings can cause or cure." The Me Too movement is an informal, spontaneous, grassroots cultural phenomenon, and that's good. We've had laws on the books for many years forbidding sexual harassment in the workplace. Those laws may be effective or they may not. In a major 2016 report, the Equal Employment Opportunity Commission's Select Task Force on the study of harassment in the workplace concluded that much of the training sold to companies has not prevented harassment. Sexual harassment training sessions, which are mandatory at many workplaces, are dreaded by employees and mocked by comedians. That's because we are dealing with fallout from the sexual revolution. This is a cultural problem, not a political one. I readily concede that my view of the Me Too movement as backlash against the sexual revolution is not widely shared. Most of the women who have spoken out have identified as feminists. Some have described Me Too as the latest chapter in female empowerment. But I'd like to suggest that whether consciously or not, many of the women who are expressing their disgust at being sexually harassed and mistreated are reacting to the obliteration of standards that the sexual revolution eliminated. Many of the accounts we've heard about in the past 2 years, thanks to the Me Too movement, show not just that some men are behaving like louts, but that some women do not sense social support for their discomfort. They've received no guidance from our culture about what kind of sexual behavior is acceptable and what isn't, about what they can object to and what they shouldn't. Consider the example of Harvey Weinstein. Again and again, he asked actresses to meet him in his hotel room, and they did. Sometimes he greeted them in his bathrobe and asked for massages. Many, many women have said he sexually assaulted them. He seems to be a vile abuser and nothing justifies his actions. But why did the women ever agree to have a business meeting in a hotel room? There ought to be an understood social code about that kind of thing so that no decent man would ever suggest such a meeting and any woman would instantly decline on principle. Here's the vocabulary. I don't have business meetings in men's hotel rooms. Perhaps Hollywood is a special case. There's always been a casting couch. But take the example of Mark Halperin, former political director of ABC News. No fewer than 6 women accused him of groping, propositioning, and touching them against their will. One woman described to CNN her first encounter with Halperin that included him putting his erect penis against her shoulder while she sat at the desk in his office. She said, "Given I was so young and new, I wasn't sure if that was the sort of thing that was expected of you if you wanted something from a male figure." The rules about how adults are expected to behave have become so loose that a young woman just starting her career isn't sure whether what Halperin did was normal. The confusion about what is and is not okay has also led to crazy miscarriages of justice. At a small liberal arts college in Oregon, a male student was ordered to stay away from a female classmate. He was not permitted to be in any building she was in, and he was cut off from his job on campus. But he didn't even know the other student. He reminded her of a man who had raped her at a different campus thousands of miles away. In California, 2 students were roughhousing on the playground. There were no witnesses. One student said that the other boy had touched his upper thigh or perhaps his groin. The offending student was suspended from school and had the incident listed on his record as a sexual assault. The boys were first graders. Some of the most prominent advocates for the Me Too movement have trouble drawing distinctions between immature or unseemly behavior and sexual assault. Senator Kirsten Gillibrand, for example, when she was pushing Al Franken to resign, refused to acknowledge that his conduct was any different from Harvey Weinstein's. But drawing lines where Senator Gillibrand refuses to leads to exactly the kind of absurd outcomes we saw on that California playground. See, my time is limited. I have 3 more pages. Is it all right to? All right, I'll finish up. I mentioned the Aziz Ansari story where a woman went on a bad date and decided because she was unhappy that it amounted to rape and sexual assault. I'll wrap up with this. The federal government cannot fix the problems that Me Too is highlighting. I hope that the movement will result in second thoughts about the importance of self-control, courtesy, respect, and yes, even chivalry. And I hope it will not become another battle in a long-running war between men and women. Thank you. Thank you, Ms. Chairman. Ms. Liu?
Good afternoon. My name is Jane Liu. I am the legal director at the National Asian Pacific American Women's Forum. I want to thank you for this opportunity to offer my perspective on an issue that deeply impacts many Asian American and Pacific Islander federal workers. Founded in 1996, NAPAWF is the leading national multi-issue AAPI women's organization in the country. Our mission is to build the collective power of all AAPI women and girls to gain full agency over our lives, our families, and our communities. Our economic justice work focuses on advocating for policies and laws that protect the dignity, rights, and equitable treatment of AAPI women workers. A key issue we work on is workplace sexual harassment. Since the emergence of the hashtag MeToo less than 2 years ago, the issue of sexual harassment in the workplace has gained unprecedented attention. At the same time, the voices and experiences of women of color who are disproportionately impacted by sexual harassment have often been excluded from the public conversation. In order to bring about broader systemic change for all, it is vital that any conversation about sexual harassment center the experiences of women of color workers. My testimony today will focus on the issue of sexual harassment for API women federal workers and potential solutions that the government can implement. While data show that sexual harassment is a significant problem in federal workplaces, API women workers are particularly at risk due to a number of factors. First, intersectional stereotypes of API women are pervasive and permeate the workplace. These stereotypes, such as the submissive geisha, the prostitute, and the mail order bride, depict API women as erotic and sensual, foreign and exotic, subservient, quiet, feminine, and passive. These stereotypes are racialized, and API women often experience sexual harassment based on these generalizations. Second, API women workers face power imbalances and racial and gender inequities that increase the risk of harassment. At root, workplace sexual harassment is about power used to reinforce cultural norms and to exert control over people with less power and status in society. As a result, the risk of harassment is greater in work environments with significant power imbalances and inequities. API women federal workers continue to face a glass ceiling at the senior executive service level, resulting in underrepresentation at the top levels of government. Moreover, a 2012 EEOC report found that API federal employees continue to face pervasive racial and national origin discrimination by managers and barriers to promotion. While the vast majority of individuals who experience harassment never tell their employers about the conduct, API women are even less likely to report due to particular barriers. Social stigma and the prevalence of victim-blaming attitudes in API communities are significant barriers. These attitudes are shaped in part by traditional Asian cultural beliefs that women are expected to practice modesty and sexual restraint and are held responsible for sexual activities outside of marriage. As a result, many API women do not report because they are concerned about how it would affect their own and their family's reputation. Another barrier to reporting is that API women have difficulty or are unwilling to identify conduct that is consistent with sexual harassment as sexual harassment. This may be due to fear of shame and stigma from acknowledging that they have been sexually harassed. It may also be caused by lack of knowledge of what behaviors constitute sexual harassment. Related to this barrier, many API women do not report because they are unfamiliar with the law and how to enforce their rights. API immigrant workers also face language barriers in reporting, as 35% of Asian American and Pacific Islanders are limited English proficient. The harm caused by sexual harassment to workers can be devastating. Sexual harassment has significant economic and professional consequences. Women who experience harassment are much more likely to change jobs, often to lower paying jobs. Harassment also reduces access to professional development and learning opportunities. The economic consequences can be more severe for women of color because they face greater wage gaps than white non-Hispanic women. Asian women are paid 87 cents for every dollar paid to a white non-Hispanic man, but the wage gaps are much larger for some ethnic subgroups, with Burmese, Samoan, and Hmong women making less than 60 cents to the dollar. Sexual harassment also has a devastating impact on health and can lead to depression and trauma. API women already have higher rates of depression and report significantly more suicidal ideation. Southeast Asian women with refugee backgrounds are also at greater risk of post-traumatic stress disorder. For women of color, the health effects are compounded by the negative health effects of racism and discrimination. While many aspects of the federal sector complaint process need reform to better serve victims of harassment, I will focus my recommendations on addressing some of the particular issues confronted by API women workers. First, better data leads to better policy. API women are drastically underrepresented in studies about the prevalence, nature, and impact of sexual harassment in the federal workforce. Therefore, each agency should adopt practices to collect disaggregated data that tracks sexual harassment complaints in each department. In addition, agencies should incorporate mechanisms to fully understand the breadth of harassment, such as anonymous department-wide surveys or holding focus groups for women of color. Other steps that the government should take include education and training of workers and employers on racialized sexual harassment and intersectional stereotypes, making educational and training materials for workers available in other languages, ensuring access to interpreters and translators throughout the complaint process, training of EO counselors and managers on cultural competency and trauma-informed care, implementing a variety of reporting mechanisms other than the EO complaint process, particularly more informal mechanisms that guarantee anonymity for complainants, and implementing culture change strategies in agencies from the top down that systemize accountability, reduce power imbalances, increase engagement of employees, and root out institutional inequities. It cannot be emphasized enough that sexual harassment does not occur in a vacuum. For women of color workers, sexual harassment cannot be separated from racism and other discrimination. Therefore, efforts to address sexual harassment cannot be siloed from broader efforts to make federal workspaces more inclusive and more equitable. Thank you.
Thanks very much, Ms. Katz. Madam Chair and distinguished commissioners, thank you for giving me the opportunity to testify today. My name is Deborah Katz, and I am a civil rights lawyer based in Washington, D.C., and I've been doing sexual harassment work for 35 years. I had an opportunity as a very young lawyer to work on meritorious savings, so this is work that is very important to me, and it's work I have great familiarity with. And in that vein, I was asked to testify as someone who is passionate about eradicating sexual harassment in the workplace, but I do not take cases in the federal sector. And I think that's why I'm asked to testify today. The fact is that for many practitioners who are really passionate about this area of the law, we find litigating cases in the federal sector to be too expensive, too cumbersome. The results are just not adequate, and many of us just simply opt out. So I think I can lend my expertise to talking about factors that lead many people like myself and many firms like ours not to undertake these kind of cases. But before I start, I just want to reference one comment. I also represent victims of the Harvey Weinstein company. And sexual harassment is about abuse of power, plain and simple. Developing codes for better civility is not what sexual harassment is about. And I just feel that it's very important to put a point to that and make clear that as long as there are individuals in the workplace who have power over others, you're going to see sexual harassment unless you have really robust laws that protect people from this kind of invidious discrimination. So Congress should be a model employer. Congress should make sure that the federal government are model employers and adhere to the spirit and the letter of our anti-discrimination laws by addressing longstanding obstacles to preventing, reporting, and remediating sexual harassment. In the federal workplace, there are significant barriers that impede individuals from getting adequate representation. Access to lawyers is essential in the sexual harassment context, where there are powerful systemic barriers to reporting and pursuing complaints. The uniquely intimate and often traumatizing nature of sexual harassment makes coming forward especially challenging for most workers, and retaliation, of course, adds another layer that deters people from coming forward. So having strong, effective advocates is crucial to being able to successfully bring claims. So what are the three factors that we have addressed in our paper that deter plaintiff side attorneys from taking these kind of cases? The first is the statute of limitations for federal employees. It is indefensibly short. While public sector employees have have to bring their claims within 45 days. They have to contact an agency within 45 days. People in the private sector have either 180 days or 300 days, depending on their state of residence, to file a complaint with the EOC. 45 days is just not enough time. During a 45-day period, you often find people so traumatized, so unable to even consider their options, so fearful that they do not initiate EEO counseling, and forever they lose their claims. That is just outrageous. And once the EEO office completes the counseling, they have only 15 days to file a formal complaint with the agency, or again, they lose their right to pursue their claims. Who is that benefit? If we care about eradicating sexual harassment in the federal workforce, we need to extend the statute of limitations. These short statutes of limitations put the burden on victims to preserve their claims, and that makes it much more difficult to obtain representation. I can tell you that we receive calls on day 43 quite often, day 45 quite often, and day 50 even more often, and it's just outrageous.
So that's one factor. The second is the multi-layered idiosyncratic federal sector complaint procedures and years-long resolution times further complicate this area of the law. Because each federal agency adjudicates harassment claims within its own internal EEO offices, federal sector practice requires a blend of both administrative and employment law skill sets that few attorneys master. You may have familiarity with one agency, but not with another. And as a result, it is very difficult for lawyers who practice even federal sector EEO law to take cases across the board against different agencies. And even the briskest path through the required steps take at least 7 months. In most agencies, the times are significantly longer. And during this process, attorneys must manage EEO office procedures that vary across dozens of federal agencies. They have to manage the innate conflicts of interest, both conscious and unconscious, that arise in adjudicatory proceedings carried out by the very agencies that are defending against an employee's claim. So this is very problematic as well. And the third is just the economics of this. Many plaintiff-side attorneys simply financially are unable to undertake federal employment claims due to the combined effect of relatively lower federal wages for many workers and Title VII's outdated, inadequate damage caps. The lack of punitive damages, of course, from federal sector claims is another factor, but we are dealing with 1991 levels that have lost at least 40% of their value and they've not been looked at, and that has to be addressed. For attorneys such as myself, most of our work is done with statutory fees or on a contingency fee basis. The reality is most individuals cannot afford legal fees. So when attorneys look at federal sector cases and you're looking at the fact that the caps are low, there are no punitive damages, the delays are enormous, the process is Byzantine, the results are really often quite uncertain, these are cases that most plaintiffs' lawyers do not take. And it makes access to legal counsel very, very difficult. So looking at the complex, time-consuming administrative proceedings that are more labor-intensive than most private sector litigation leads to a perception that these cases are onerous and they weigh against an attorney's taking private sector clients. That's just the reality. I'm a member of the National Employment Lawyers Association. I'm a member of the Metropolitan Washington Employment Lawyers Association, and I can tell you that just a small segment of both bars, and we are passionate about these cases, handle federal sector cases. So things really have to change. Legal representation is central to the vindication of civil rights, and in the context of sexual harassment specifically, barriers to access can seriously erode protections of workers who already face unique personal and professional harms. Thank you for your interest today.
Thank you very much. I'll open for questions from my fellow panelists. Commissioner Nicolay?
Ms. Katz, could you help us understand the impact of Executive Order 13839?
Yes, but I'm not sure anybody quite understands the impact yet. The problem is that it indicates a hostility from this administration to the very remedies that are necessary for workers. Usually,
Ms. Katz, so we have a couple of commissioners who are on the phone. If you don't mind just leaning forward to your microphone.
Oh, I'm sorry.
Thank you.
I'm sorry. The executive order, by limiting whether records can be fixed, really takes away one of the central tools that's necessary to fixing problems of discrimination. Often the records contain, when discrimination is found, you have discriminatory personnel actions reflected in those records, you have disciplinary actions reflected in those records, you have unfair job appraisals affected in those records, and if those records can't be corrected as a condition of settling a case or as part of an adjudication of the case, that discriminatory record follows the worker throughout the worker's career. And it's extremely problematic. It's one of the reasons that people often seek out legal counsel, is because they've received a discriminatory evaluation that they know they will never advance unless that's fixed. So that executive order is extremely problematic, and I hope we never really see it be implemented.
Ms. Rodriguez and Ms. Katz, I guess this you as well. Would you speak to what specific recommendations you would have for making the federal enforcement in this area more effective? Enforcement specifically, not just training enforcement.
Well, I spoke to statute of limitations issues. I mean, crucially, that probably bars a vast percentage of workers from coming forward. And I think that making the practices at federal agencies more uniform and more transparent is crucial, because if you can litigate cases against one agency, you should be able to use the same steps and the same tools to approach other agencies. And it's just not like that. It's all idiosyncratic, and that's significant. And then the timeframes that are in the regulations for what it will take to get through these various processes need to be adhered to. Now, I understand that's a real resource issue, but the fact of the matter is some of these cases drag on for many, many, many years. And it creates a huge disincentive when combined with a fear of retaliation for anybody to come forward. They look at their peers who have had cases pending for many years, and they see that that person during the period not only has had an adjudication of their case, but they've suffered retaliation. So these deadlines are important and they're meaningful and need to be adhered to. So that would be another. And then there are agencies that do things like, okay, we'll resolve your case, but we're not going to pay for the attorney's fees that were expended in the administrative process. And knowing that, I mean, from my perspective, it's best practice to try to resolve every case I can at the lowest possible level. A good day for me is resolving something before somebody ever has to go to court or ever has to file a charge. And in the private sector, that's pretty common. You approach the employer, you say, this is the problem, the person's been discriminated against, you enter into discussion, you provide evidence, sometimes you go to mediation. It's a flexible process that is designed to resolve disputes before they become legal problems. And there's just nothing analogous for most agencies, and that's extremely problematic as well. So I would like a policy prescription that allows mediation and provides fees for lawyers to incentivize them to take cases through that level.
Commissioner, I was here for the last panel when you brought up the point that institutions respond to legal risk. And I think that there's a lot of truth to that. In a prior life, I was a management side attorney, and I advised employers on diversity and inclusion and EEO matters. And there is something to be said about requiring employers to report to a federal government agency on their, for example, their workforce demographic numbers, right? Or to report to the Department of Labor, OFCCP, on their affirmative action practices. It requires businesses to look internally first and to see what's going on and to identify barriers to equal employment opportunity, and if those are there, to address them. And so I think that there is a lot to be said about increasing transparency for federal government agencies with respect to how many complaints they're receiving, how they're being investigated, what conclusions are they arriving at, what remedial action is being taken. And by requiring federal agencies to track that type of data, it will require them to identify whether there are any trends that are being revealed in particular departments with respect to specific supervisors, for example, and it will put the federal government agency in a much better position to address any issues that may arise, and it would also increase the ability of the federal enforcement agencies to take action to address them.
Your microphone's not on.
I can speak to, I've had a number of conversations with women that have experienced sexual harassment in the workplace. And one of the areas that I think needs more focus is the informal and pre-complaint process. I've heard from a number of women and also their attorneys that women have had very negative experiences in dealing with their EO counselors, and almost from the get-go, sort of being like the EO counselor is trying to deter them from proceeding with their complaints. That there's sort of an accusation there. One woman was saying that the first question the EO counselor asked was, "What do you want? Like, how much money do you want?" Like this, that was like sort of the accusation was, "You are only doing this because you want damages." And I think that I've heard that from a number of different women. And the other thing that has become an issue is that in this sort of Me Too climate, there's sort of a desire to sort of sweep these issues under the rug. So they will give the employees sort of the remediation that they're requesting, but not order the supervisor, the manager, or sort of the higher ups to undergo any sort of training, or there's no corrective measure being taken against the managers. And even sometimes the harassers themselves, they're just putting them on administrative leave for a week or something like that, and then but nothing really changes. So that's something else that I've also been seeing among federal workers.
Ms. Katz, you talked about greater uniformity to which I can see the merits of. One of the things that we've heard is that because there is such a variation in the size, nature of the workforces, sometimes the geographic situation, international situation of certain agencies, that there are some complexities in figuring out what a common approach would be. How do you respond to that? And do you think that there is some baseline set of core minimums that can be put forward as a best practice?
Well, I'm not a subject matter expert on that, but I do think that there are always best practices that we can look to, and there should be best practices implemented regardless of these issues of size of agency and geographic disbursement of workers. I mean, that needs to be factored in, of course, but there are certain best practices. The one you just spoke to is how completely sometimes counseling is good and sometimes counseling is really not good. And there are best practices for how to conduct counseling. It may be that it's a perfectly innocuous question to ask, what are you looking for? But when it's approached in a negative way, that can be deterrent. So I think that at every step, there are best practices for how to talk to workers, how to understand what workers are looking for. And I think that we can draw on expertise of people who have good practices in their agencies. I think we can all identify what bad practices are. I guess that's easier.
In our last panel, we heard a fair amount of testimony from a couple of panelists about raising real concern about whether these issues are even legal issues or even best addressed as legal issues. And Ms. Chair, I hear a strain of that in your testimony as well. I wonder if the four of you could speak to the degree to which the law is equipped to address the kind of sexual harassment that is coming up in the employment sector. I know that you typically don't practice in the agency sector, but I think that the questions are reasonably universal for that purpose. And if the law is well enough equipped to address it, where are the deficiencies and how do we address them now? If it's not, is this in fact a management question that can be addressed externally?
As I suggested in my testimony, I think this is a social problem that probably it's easier to handle, well, not easier, but best handled by informal changes in mores in our society. The law is a very blunt instrument, very clunky. We've seen that, as I mentioned, the sexual harassment training and various laws regarding this are not working very well. There's still a tremendous amount of sexual harassment in our society. And maybe it is a moment for thinking, how else can we begin to approach this in ways that employ social shaming, that insist upon certain standards of behavior for everyone. If it were a society-wide effort led, say, by celebrities, by comedians, by important figures who have prestige. Something along the lines of the Gillette ad. If you see that, but it was an ad that purported to show how men can be real men without being louts. It showed men correcting one another when they were being harassing and or just inappropriate. That's the kind of thing that I'm hoping to see more of, where it's informal, it's bottom up, and people will respond to social shaming.
So, as we've discussed, Commissioner, a lot of survivors do not come forward to complain in the first place, and there are local, state, and federal laws that prohibit discrimination and harassment on a variety of protected categories. But despite that, a lot of people still don't come forward forward to file complaints. And so, yes, it's absolutely a legal issue, but I think it's also a workplace culture issue. And ideally, workplaces have the tools in place to ensure that these issues don't happen in the first place. And if they do, that the agency is equipped with the resources that it needs to investigate them properly, promptly, and to take remedial action as quickly as possible. I've done EEO trainings, and I think that they are incredibly important because, as a prior panelist said, they set the tone. And it also gives leadership an opportunity to convey to the agency or to the organization what the policy is, and that there is zero tolerance for harassment or discrimination. And EEO policies are not in place to let people know that they need to violate the law before they get in trouble. That's not the standard within a workplace. The standard is you cannot engage in harassing behavior, and really that's determined by the recipient. And so the purpose of training is to let people know what is acceptable and what isn't. And so I think that when we're talking about practices that should be standardized among agencies, I think it's very important for each agency to do an internal assessment to see what their EEO system looks like. Is it really equipped with the resources that it needs to adequately respond to the workforce at hand? I think where we may see variations is the different types of workplaces that exist, right? Are we talking about a workplace that has a lot of employees that are out in the field, or a lot of employees that are in offices? And perhaps then, based on those differences, you develop different types of training and investigatory methods. But I think that first and foremost, the first response to workplace harassment has to be an internal response.
So I clearly think it's a legal problem. Sex harassment is just one form of sex discrimination, as the Supreme Court said in Mariner. We certainly have no problem seeing that the law should have something to say about discrimination in other terms and conditions of employment. And sex harassment is a form of discrimination. It's within a range, and it persists because of power differentials in the workplace. So if we're looking at all of this, we need to look at pay, we need to look at promotional patterns, but it's all part of one thing, which is discriminatory patterns that keep certain workers as the underclass and leave them most vulnerable to this type of invidious discrimination. So yes, the law is very much necessary to try to rein in this kind of behavior. The problem is, in this moment of reckoning with this Me Too movement, we all are now understanding undeniably how pervasive this problem is. And we're shifting culturally, but our legal institutions have not shifted. We're seeing some good work being done on the state level, but at a time when the world is really coming to terms with how pervasive sexual harassment is, we have one of the most reactionary administrations in the history of this country. And the fact is, we're not going to get anything through Congress right now, and that's really a shame, because we understand now that there are certain things that we're all looking at. And one of the things that doesn't pertain to the federal sector, but mandatory arbitration is something that we know now covers 68 million people in the workplace. 68 million people in the workplace cannot go to court. And we know that when people are denied that opportunity, people actually don't bring these kind of claims, and a whole host of ills that come from that. But in terms of the issues that are in front of you, we have a huge segment of the workforce now that has no legal protection because we're calling them contractors. And in the federal workforce, there are 4 million independent contractors. And we saw what happened to those during the government shutdown. Federal workers got their money back, contractors did not get their money back. They're particularly vulnerable because of the work that they do to issues of sexual harassment in the workplace. And yet, for many of these people, they have zero legal protection. And I think the law just needs to identify that and redefine what are employees. Employees should be all workers whose conduct is within the economic control of the employer. But that's not what we're doing. And as our economy changes, and we have a 21st century economy, the law has not kept pace with what the realities of the workplace. With that, I would also say that
Sorry, does that definition exclude interns?
it might. I mean, the EEOC has taken a position on that, but cases are all over the place.
But to the extent we're defining it, would it be your
Yes,
intention
it
to?
would. People who work within the control of an employer or controlled in how they conduct their work. Yes. The other is the issue of vicarious liability, which we saw in Vance versus Ball State University. And in that case, the Supreme Court defined supervisor in a way that created a distinction that basically creates an out, no liability for employers when someone who is, for all intents and purposes, the supervisor of that employee, there's no liability. So I think that we need to look at the Vance standard. I would love to see the Vance standard through some kind of Civil Rights Restoration Act of 2020. I would like to see that law changed. I think it has to change. As I said, damage caps are really important. And just the whole issue of severe or pervasive as the standard for sexual harassment. I know it's a long-standing standard, but the problem is it's like a Rorschach test. If I'm in front of a conservative judge, 5 grabs, 2 sexual propositions, those kind of things, a conservative court would say it's not severe, it's not pervasive. You go before a more liberal judge, they would have no problem with it. And again, there's going to be discretion in how courts look at these kind of issues, but the severe or pervasive standard just lends itself to much more subjective look at some really terrible things that happen. Workplace is one workplace is actionable and the other is not. And one last thing I want to say about training. I think training is really important, but it has to be tailored to the actual workplace, and it can't be a check the box exercise. We really have to start looking at this in terms of Ellerth and Farragher as a liability mitigation issue, and really say if we care about eradicating sexual harassment, training has to be effective. And to be effective, it really has to look at the realities of the workplace. And I think bystander training is very important. Often people are uncomfortable with the discrimination and sexual harassment they see in the workplace, and they don't have the words to interrupt it. And people, not just the victim of harassment, but coworkers feel very disempowered because they don't know how to step forward and they fear retaliation. And I think bystander training is a very vital part of this whole thing. And training also, last thing, can't be, and we've seen this, where people have come to us and said, as a result of the training, we're being sexually harassed more than we ever were. Because they're taught in sexual harassment training that it has to be severe or pervasive. Well, it could be, and people are, and I've seen training that says, you grab somebody 5 times, this court says it's not severe, and it's ha ha ha. Or, sexual harassment is not designed to get rid of boorish behavior in the workplace. Well, one person's boorish is another person's serious, offensive, discriminatory. So I think training has got to not teach people how to sexually harass under the radar, and that's often the case.
Thank you. Isla, did you want to answer that?
No, I think the only thing I wanted to say was I don't think it's an either or proposition. I think that, to the extent that there is obviously this is a cultural issue as well, and so that cultural work can go on in private spaces, but that doesn't preclude the government from also ensuring that their workspaces are safe and free from discrimination or harassment. And so I don't think it's something that, obviously legal protections matter, and that work always needs to be done, and also there's cultural work that that needs to be done as well. And I think the government is also responsible for the culture that they create in their workspaces. So I just want to say that they're not mutually exclusive.
Thank you. Mr. Padley?
Thank you, Madam Chair. Ms. Katz, I prefer to go to court as well, but are employees entitled to agree to arbitration if they'd like?
Are employees in the federal sector?
In the federal sector.
Are they free to do that?
Right.
Most agencies I've seen do not have the ability and cooperation. I'm not aware of any agency that offers arbitration to employees.
Okay.
In the private sector, of course, that's become more common than not.
Anybody else know? Okay. My second question is, and I don't know the answer to this, so I don't want to appear to be really dumb, but I probably will. A contractor in the private sector is, I think the IRS has 4 standards for what a contractor would be or employee would be before they develop that. Does the federal government have to live up to that same standard? In other words, if I contract with somebody and they come to my workplace 5 days a week from 8 to 5, and I direct them and I do all that stuff, that would be an employee in the private sector. What about the public sector?
I think that you're looking at the same standards, what dictates an independent contractor in both systems. I mean,
So they can bring an action if they like. Is that correct? If
they're misclassified, they can bring an action.
Right.
If they're misclassified, but if they're classified as a contractor, they cannot avail themselves of Title VII protection.
And one more question.
Yes.
Do you have the perfect definition for severe and
Severe or pervasive?
pervasive?
Boy, that's a great question. I probably should work on one.
That's why I saved it till last.
Well, I think what I'm saying is maybe that's not the right test because it's so subjective. Clearly, the case law has evolved that a sexual assault, even if it's one time, is sufficiently severe to constitute sexual harassment. But something that is a threatened act of sexual assault may be equally harmful and damaging and career derailing for somebody in that workplace. And you have many courts that say a threatened action of sexual assault might not be severe enough if it's a one-time thing. And so I think that we need to look at those definitions.
But there's no definition that gives a brighter line in your mind at this
No,
point.
in fact, the Supreme Court has been very clear in saying you look at the totality of the circumstances, there's no bright line test, and that's why we see cases all over the place. And the problem is many of these cases break out on summary judgment, where you have a court saying as a matter of law it's inadequate, and if the case went to the jury would more often than not find that there was harassment.
So we'll look forward to your testimony in the public comment period if we could. So thank you. Commissioner.
I want to actually follow up on the issue of how would we define this if we had a Congress that could act and would act and in a perfect world. So I invite people who have testified to submit within while our record is open for 30 days, suggestions, because that's what our job is, to make a recommendation to Congress about what laws need to change. It's not enough to say this law doesn't work. We actually have, it's more effective if we could say this would be better. So I invite you to do that.
Sure.
The second is a lot of our questions today have been focused on how do you get at retaliation, right? Because that seems to be one of the major barriers, and people, I think, quite rightly are making the assessment of it doesn't make sense for me to even raise the claim. So what do you see? Like, how do you get supervisors and others to not do that in the first place, to be disciplined if they do? It's not, in the questions we asked this morning, it wasn't clear to me whether they get disciplined for retaliation. So it would be very helpful to hear what you know about that question and your thoughts about how we could get at that problem.
Commissioner, so when agencies are conducting their internal EEO training, I think it's critical to ensure that a significant portion of the training is dedicated to retaliation, both for employee training and also for supervisory training, particularly for the supervisors to know what the policy says in prohibition against retaliation, so that all employees know what the policy is, to know that supervisors who retaliate are subject to discipline up to and including termination, right? So that it's very clear that retaliation has very serious consequences. And for the supervisors to know that retaliation is not very hard to prove, and that there is a real serious risk if an employee alleges that they've been retaliated in addition to having been harassed. I think that for some supervisors, they're not really sure how broadly retaliation is defined. And so I think that there is real value in providing concrete examples, right? Not giving the employee any more assignments in other examples. So I think that training is a critical piece of that. And it's not just a once in your sort of tenure with the company type training, but a training that occurs regularly.
Those are good answers. There's a perverse problem with the law. If someone comes forward, and we want employees to come forward and report harassment, discrimination as quickly as they can, we want that. Well, in the sexual harassment context, in the racial harassment context, there's case law that's evolved that says if somebody comes forward and they suffered some job action, but they have not engaged in protected activity, right? They've complained about behavior that itself is not actionable because they've only been grabbed once. They've only been sexually propositioned once. And then they've suffered retaliation. There's case law that says that's not retaliation because they haven't engaged in the underlying protected activity. And there was a horrible Fourth Circuit case. It was a race discrimination case where someone was subjected to really vile, racially hostile remarks. And the court there said, well, no, they clearly suffered adverse action, but the fact is they came forward, in fact, too soon. And if we're trying to tell employees, you need to come forward and seek out the help you need without fear of retaliation, I've had people come to us and say, you know, if you come forward and you complain about this and it's pretty soft right now, you don't actually have protection from being retaliated in the workplace. And that's something else that's
So is that an area that we would need to fix legislatively, or is that government agencies need to talk about how that's just bad management?
You also have cases that say, well, shunning somebody in the workplace, you know, not inviting them to things, putting them in a bad room, that may not be actionable under Burlington, because would a reasonable employee in that position feel that they wouldn't come forward in that circumstance? And we would say, sure, you know, being shunned, being moved, having your duties changed. But often employers and agencies employ a test that I think is too restrictive, which is whether it affects you in your pocketbook. And those are the conditions that affect somebody day to day. Are you on the night shift, you're on the day shift? Do you have meaningful work? Do you not have meaningful work? And I think that that's both a training issue and how we define it.
And are you aware of whether the federal government has ever fired anyone, supervisor, for retaliation? When I asked the State Department person, he couldn't answer the question. The department is so big, I would think that would be an easy thing to answer. So you don't know either. You haven't
read about it in the newspaper.
Yeah. That's what I wonder about, if you're trying to deter people from retaliation. If you don't know anyone who ever lost their job or was seriously affected by having done it, then why not, right? if you're of that mind. I am wondering, after hearing about sort of concerns about the EEO counselors, what kind of training do they get for their jobs? Is there a sense that there might be a need there to look at? Our court reporter doesn't report bodies, so unfortunately.
I think generally, yes. And I can't speak specifically to the federal government, but generally, in my experience, yes. I feel like it's an area that is often overlooked, and it's very important to ensure that EEO investigators are properly trained on best investigatory practices, on how to promptly respond and investigate a matter, on how to determine credibility, which is often sort of an area where investigators get tripped up. For example, if there is a situation only involving 2 employees and there is a 3rd employee to corroborate what happened, you have to determine if the person making the complaint is credible. And oftentimes what I've seen in my practice is that if you only have 2 people, the EEO investigator will say, well, there isn't a 3rd person to corroborate, so no finding, right? And so I think training for EEO investigators is very, very important.
I'm definitely not. I think that there's, I've just heard such wide variation in experiences with EEO counselors. A lot of interesting evidence. I've looked at the same thing that EEO counselors will make legal judgments that will be like, well, that doesn't constitute and so I think it varies a lot, and I think it needs to be a lot more community I do think, and I don't know if this is required, but I do think that based on what I heard from the student competency training and understanding how difficult, especially as someone who advocates for API women, it's already really difficult. And so when an EO counsel meets you with a semi-accusatory question, it is very difficult to find a form of process. I've heard from women that it's very demoralizing to go to an EO counselor and read it like a question. It was difficult to walk through that before. The rest of the process is just so I think that I would definitely feel the need for training and working with I also get the sense from a lot of the women that I've spoken with also feel like the EO counselor is really working with the agency. They don't really, they're working with the agency to resolve the case and to make it go away versus really trying to address the issues, broader cultural issues. That is something that I think should also be addressed through some kind of training or some kind of education process.
In our earlier panels, someone made the suggestion that perhaps government agencies needed to have a special advocate position, who would then, instead of being seen as the employer's spokesperson, someone who could help people go through the process, understand the process. What is your reaction to that? Good idea, bad idea? Would put private attorneys out of practice?
The Congressional Accountability Act was modified, and Representative Spear spoke about it. That was one of the things that was set up was because many of the Congress then have counsel go through that process to provide counsel. There's a real problem with that act. There's no real accountability to the members, so we don't know if the members have come up having that kind of advocate. But I think in general, that's a good thing.
I have one more question. So we've heard a lot about training, and I myself have seen really, really bad diversity training, and how you need to really need to test out whether in fact the training is having the impact that you intended. People have brought up today the issue about culturally responsive training, the understanding of intersectionality. Are you aware of good training? Is there, if so, I would, that has been, and if there's any research around that, I would invite you to share that with the commission. That would be extremely helpful.
The EEOC Select Task Force has a whole section on the training, and I think that there's a lot of subject matter knowledge there, but there are studies cited for what is efficacious and what's not.
Yeah. Yeah, I'm particularly interested on the issue of Latinx and Asian women, because I feel that sort of we're seen as a newer phenomena, and I don't know how much research has really been done specifically around women who come from those different cultures. Thank you.
Commissioner Degler?
So our topic today focuses on discrimination in the federal government, sexual harassment discrimination in the federal government. So I'm interested if we can perhaps go down the line, the panelists' views about whether or not this form of discrimination, when it's perpetrated in the federal workplace, poses special harms.
Well, we've heard the term model employer over and over again, and the federal government is the largest employer. And as I mentioned in my oral comments, for the African American community in particular, it's been a pathway to the middle class. And the federal government sets the tone for everybody else. And so I think it is very important for the federal government to hold themselves to the highest of standards to ensure that they are implementing the best practices to ensure that there is no harassment in the federal government. Federal employees come to the workplace day in and day out to serve their country. And while anyone who experiences harassment obviously suffers from very serious harms, I do think that the federal government has a special obligation to do everything that it can to solve this problem.
I agree, and I also think that when sexual harassment is permitted and enabled in the federal sector, taxpayers are funding. Taxpayers are paying the salaries of people who are harassing workers. And while you might in the private sector have shareholders who decide this person is so crucial to our mission, we're going to allow that person to stay on this. That's not a decision that should ever be made in the federal sector. And taxpayers should not be funding this kind of violation of discrimination law and define our nation's commitment to equality. And we need to have this more than a slogan, this model employer.
I mean, I think I also agree. I want to share an anecdote because I heard I was speaking with lawyers that represent a Burmese woman in the Bay Area who has brought a lawsuit against the Daily City Post Office on sexual harassment case. And this woman has been working there for 18 years. She's an immigrant, and the treatment that she's gotten in terms of going through this federal sector complaint process, it's been very difficult for her psychologically. And some of that is because she just can't reconcile the U.S. government treating her that way. It's just she's been 18 years of her life just serving in the public sector, and for them to treat her like, accuse her of just wanting money or, not taking her complaints very seriously, not valuing her safety. I think it's a particular, in that sense, it's a particular meaning for her, even just as an American. So I think that sort of illustrates.
This could be an area of competing goods. One of the things that the federal government has provided to its employees is a lot of job security. It's very hard to fire somebody who is in the federal workforce. It requires a lot of proof. There are a lot of protections, and that's a good thing. But it can stand in the way of holding people accountable for really bad behavior. So it can insulate some people from actually being punished when they deserve to be. So I do think it's a problem that comes from competing good things. And in the private sector, there is less of a there's more discretion on the part of employers to hire.
Ms. Katz, I think you alluded to this point earlier, but I just want to clarify. Is there a statutory cap on damages for these types of claims?
Yes, $300,000.
And what is your view of how that number functions to help police the problem?
Well, I think the number is too low. It creates a disincentive for somebody to risk their career to come forward to, everything goes their direction. They're entitled to $300,000 of compensatory damages. And proving compensatory damages is very difficult. You need, typically, if you're dealing with emotional distress damages, you're dealing with needing to have an expert testify in very basic discovery. I think those damages need to go up significantly. The caps need to go up significantly, and certainly to keep pace with where they were in 1991. Wall Street public 40% of their value.
And what do you think the cap should be?
Oh, for this kind of behavior, $10 million per person. No, it needs to be really high. It needs to make the cost be something that when someone engages in this behavior and a settlement has to be paid, that federal agencies, employers in the private sector think twice about whether they want to countenance and enable this behavior. When the cost gets too high, they'll crack down. So it has to be high.
Of course, it is taxpayer money, right?
Well, yes, it is that. So then get rid of everybody who engages in this kind of behavior.
We'll end this panel now, and
The employment lawyers sack everybody.
thank you very much for this vibrant panel. Also, we will reconvene at 5 p.m. for the public comment period.